So today our topic is anticipatory bail. Now, as we have been hearing and reading a lot in the newspapers that this person got bail, that person got bail, such and such case is registered in certain court. We have been hearing about the word bail a lot of times. But what does it actually mean? Now, when a person gets arrested for committing a crime, he is put into jail. This is what we commonly know. But there is certain procedure that is being followed. Prior, he's been put into police custody for interrogation, and then he's been put into prison. As a principle of law, we believe that a person should not be restricted of his actions and he should not be put into jail or a prison. Therefore, there is a provision of bail in law, and we believe that bail should be granted and the person should not stay in a confined space called jail. But is this a cardinal rule? Is this that we are just going to follow and give bail to everybody? The answer is no. It depends and circumstances of the case. If the case is such that the crime committed is so grievous, it is so grave that the person cannot be let scot-free, we have to put him in jail and we have to keep him inside a confined space so that we justify or rather we protect other people from such a dangerous person. Now, bail means the person is released from police custody or judicial custody. Bail also consists of certain restrictions. You might have heard that the person is restricted. He is not allowed to go abroad without permission, prior permission of the court or the police officers. So there are such restrictions which are called pre-trial restrictions which are imposed while granting the bail. Now, who grants the bail? Depends on the case. First, it goes, whichever case goes to the metropolitan magistrate, the metropolitan magistrate grants the bail. If the case is pertaining to sections such as 302 IPC, 307 IPC, these cases go to Sessions Court, and thereby the Honorable Sessions Court has got the power to grant bail to the accused in such cases. Now, what does bail do? It ensures that the accused is being served justice. He is not unnecessarily confined in jail. But at the same time, we also have to see that the judicial process is not hampered by the actions of this accused. So this is the premise or the general understanding of what bail is. Next, now there are certain provisions in law for bail. You must read provisions as to bail and bonds in chapter 33 of CRPC, where section 436 of CRPC talks about granting of bail in bailable offense. Section 437 talks about granting bail to an accused in non-bailable offense. Section 438 talks about the power of the Honorable High Court and the Honorable Sessions Court in granting anticipatory bail applications, which we are going to talk about today. And section 439 talks about interim bail. Next. Now, what are the different kinds of bail? You must be thinking that anticipatory bail, or you must have heard that it is just one kind of a bail. So what are other bails? Now, one is regular bail, that the person is granted after he's arrested, after he's interrogated in police custody, and he's put into MCR. What is MCR? That is judicial custody. And then he is granted bail by the regular court. Second is anticipatory bail. We'll see that later in depth. Third is interim bail. So there is an ongoing process that the case is going on, the trial is going on, and the person is given bail, that is interim bail. What is default bail? Now, the police has got 3 months, 90 days to file charge sheet against the accused after doing due investigation, inspection, collection of evidences, of whoever concerned people. But if they fail to do so within the given timeline, then the court has the power to give him bail, grant him bail. That is default bail. And lastly, medical bail. So it is given on medical grounds. Say the person has suffered heart attack. He has to be hospitalized in some ICU. He cannot be kept in jail, right? So he is granted medical bail. But it is also the responsibility of the court and the metropolitan magistrate or the sessions court magistrate to look into the facts and circumstances and to confirm whether his medical condition is such that he needs or he requires medical attention all the time and he cannot stay in jail. So this is the responsibility that lies with the court. Next. Now, what are the three categories? As I mentioned earlier, bailable offense, non-bailable offense, and I also spoke about anticipatory bail. These are the three broad categories that we can divide bail into. You can look into it, you can Google it and read a bit on that. It only says that bailable offenses, you can get bail quite easily because they are bailable. Non-bailable offenses, you will have to put forth certain grounds, certain reasons as to why your accused should be granted bail and why he doesn't deserve to stay in jail because it is a grievous offense as compared to bailable offenses. And thirdly is anticipatory bail. Next. So now we have been talking about anticipatory bail since our session has started and we'll look into it in depth. Now, what is the meaning of anticipatory bail? So basically, any person who is anticipating, anticipation is apprehension. Now, the person is apprehending that he may be arrested with connection to a crime that has happened in a certain place. That person can apply for anticipatory bail. So this is also called as pre-arrest bail. Say, for example, police knocks at your door and says, such and such crime is committed, sir, and you are an accused in this case. I am here to arrest you. Please accompany me to the police station. The person, after opening the door, pulls out the drawer, shows him a paper saying, look, I have an anticipatory bail with me. So what is this anticipatory bail? He knew that certain thing has happened. He knew that maybe he may be arrested. So he has already approached the court. He has put forth his contentions. He has put forth his own points. And he has told the court that I have no role to play in this crime that has been committed. I am not an accused. I am not the one who's committed the crime. Please give me protection. And the court has granted him anticipatory bail. So he already has certain protection against arrest. Now, for anticipatory bail to be put in motion, there has to be a reasonable ground to believe that the person has committed a crime. For example, the crime has been committed in India and the ex-person was in USA. He may say, oh, I was not here. How can I commit the crime? I'm not connected in any way. Anticipatory bail. Also, it is important to see whether it is a genuine case against the accused. Maybe that the person's name is XYZ, but there are many people with the same name. You may find we have many common names here. So say, for example, person A was arrested and the crime was committed by person B and they have similar names, same names. Maybe their father's name is different. So it's a genuine case. He may put forth that. Now here at this stage, when we are approaching the court for anticipatory bail, the work of the prosecution is to analyze or to look into the prima facie evidence which supports the charge put on the accused. So that's the way anticipatory bail works. Next. Now here, where do we approach? Do we get it at the Metropolitan Magistrate Court? No. The Honorable Sessions Court and the Honorable High Court at state level have been given the power to grant anticipatory bail after due analysis of the facts and circumstances of the case, whatever is on record, the grounds which are mentioned, and the reasons why the person should not be arrested. They have to analyze all that and then grant the bail. Now, many advocates advise the accused to approach Sessions Court first and then they can explore whether they need to go to High Court or not. Reason being, the person gets two opportunities, one at sessions court and the other one at high court. If you can directly approach the high court as well, but if you directly go to high court, you are missing out an opportunity to go to the sessions court. So this is a general thing that people follow. Now here, bail can be rejected. It's, as I mentioned, it's not a cardinal rule that you have to get bail. Now, what are the reasons why the bail would get rejected at a certain stage? One is the nature and gravity of the accusation or the offense or the crime that is mentioned by the police is such that the bail cannot be granted to the accused. Second is, we have heard, oh, this person just went out of India, now he's not coming back. Many news you might have read. It's called person of absconding. So the person has possibility of him just going away and relaxing at some other place is high, then the anticipatory bail is not granted. Also, he may have certain opportunities to tamper with the evidence, or he may manipulate or influence the witness. In such cases, the anticipatory bail gets rejected, just like in regular bail as well. Next, now we have this landmark judgment, Gurbaksh Singh Sibia versus State of Punjab. It's a classic 1980 case. You may go through that, wherein the Honorable Supreme Court has put forth certain guidelines for the court to consider while granting anticipatory bail. And these guidelines are again reaffirmed in Siddharam Maitre versus State of Maharashtra in 2011. That's also the Supreme Court case. You should read this. Both of them tell what court should consider, what are reasonable grounds to believe that anticipatory bail can be granted or rejected, and what are the certain pointers that the court should consider, that the prosecution should put forth, and what are certain points that the accused or his lawyer should consider while approaching the court for anticipatory bail. Now, there's certain procedure that is to be followed. When the applicant files an application for ABA, the court can, for one thing is, the court can directly say we are rejecting this application on 1, 2, 3 grounds. You may be aware that the court cannot just reject or just cannot grant you bail, or in any procedure, even while pronouncing judgment, they have to give reasons as to why. So the court may cite certain reasons that this person is going to abscond. We are very much sure that he's going to tamper with the evidence, and thereby we are rejecting this bail application. Secondly, they may think that yes, there is certain substance in the submissions of the lawyer, and it is true, and it could be believed that the accused has no role to play in this crime, and they may grant the person an interim order for anticipatory bail. So they are basically giving you protection, but in a limited manner, and they may issue notice to the public prosecutor. And thirdly is, they may directly issue notice to public prosecutor without granting interim relief. So either of the three is what the court can follow. So this is the procedure basically. Now there's one more landmark judgment next, Sushila Agarwal versus State NCT of Delhi and another. Now this judgment, if you read, you will realize that there are two main, the ratio of the judgment talks about the period. Now any person would say, okay, I have got anticipatory bail in my favor, but till when is it valid? Am I going to get arrested once the trial starts? Am I going to get arrested in between? Or how does this work? The protection exists till the end of the trial. So this is one thing that is cleared in this judgment, that once granted till the end of the trial, you are protected. Nobody can arrest you. And secondly, it talks about certain restrictions or special conditions that may be imposed during the granting of the anticipatory bail. Now, the court cannot just in a routine manner put certain conditions. Okay, you cannot travel abroad, you have to give attendance to the nearest police station on every Tuesday, you have to do this, you have to do that. But they cannot impose these restrictions just as a routine. They have to look into the case. It should differ it depends on the case and the facts and circumstances. Also, the court has to evaluate the materials placed on record. So now what are the materials? Maybe there are certain statements that have been recorded. There could be an eyewitness. There could be a hearsay witness. There could be certain documentary evidences. Are these all evidences really pointing out to the accused that the person has committed certain crime? Now, evaluating this is very important. Just is not something that the court should follow. So this landmark judgment talks about the period till when the ABA may be available, the protection may be for the accused. And secondly, what do the court follow with respect to restrictive conditions or special conditions that may be imposed during granting of this anticipatory bail. Next, now what are the conditions? As I just spoke about some conditions that the court can impose while granting bail. One, that there is no rule, there is no certain kind of a typeset that it has to be followed. So it's discretionary in nature and it is guided by the facts, circumstances, and evidences that are placed on record. Remember, they have to be on record. If there is nothing on record, there is no case against the accused. So you have to go by the court record that the police has made, whatever evidences they have placed on record. Evaluating them is a very important part. The reason why we say that the court should carefully apply their mind in even during the trial of the case. So this is just the beginning, and anticipatory bail is a certain kind of a protection for the accused where the court is saying, okay, this person has probably not done anything. He has no role to play. He has no connection at all with the case, and we are granting him protection. So what are the conditions? One, the person has to be available during interrogation by the police officers whenever they require. He may cooperate. This is one of the conditions even during remand. They keep saying that the accused is not cooperating with them. So cooperating during investigation is very important. Why? Because the police officers during investigation, inspection, and interrogation are trying to dig out the truth, are trying to get to the point where they can actually arrest the criminal, the person who has actually committed the crime. So interrogation is a very important part of the whole procedure. And the person should make himself available or cooperate with these officers. Secondly, of course, he cannot just dissuade or induce some threat or make false promises to persons acquainted with the facts. Now, the person who is acquainted with the facts could be the witness in the court. Maybe the person's statement is recorded by the police or is going to record, saying that, okay, I have seen such and such person below the bridge at 4 o'clock. So this may be favorable for the accused, or it may be something like an eyewitness to the crime that has been committed maybe below the bridge itself. So threatening the person or making false promises or inducing him, saying, okay, I'll pay you 50,000, don't say anything against me. So this person who is being granted bail, who is being given protection, should always remember that he is just being protected against arrest. He is not scot-free to do all these kind of things. So these conditions are imposed to stop these kind of actions by the accused. Now again, the person shall not leave India without permission of the court. Sometimes they also mention that they have to put forth their attendance every Tuesday at the nearest police station, so, or twice a week, thrice a week, in cases where crime is grievous or it is of very much grave nature. They do put forth certain such kind of conditions wherein the person will have to give attendance twice a week, thrice a week. If it is not that grievous, they may say once a month. So also leaving India is something that is a primary condition in big cases and big crimes, such as so say for example there's some scam, the person may just leave India and flee away. So what they do is they just forfeit their passport, seize it, and keep it with the investigating officer at their place, so that the person cannot leave India without passport. So these are certain conditions that are being imposed. Now, another one is that such a person will attend the court. They will work with the condition of the bond that is being executed. Next one is that they shall not commit offense of similar nature. Now, if the person has committed a crime under section 379, which is theft, the person is released on bail, and again the next day the person comes with the crime saying he has say stolen somebody's phone. So again he is in the jail for the same offense or of similar nature. So this is certain kind of condition. So there is an habitual accused who is committing thefts. Maybe he's stealing phones all the time. So this is one condition. And lastly, again, it is about inducement or threat or promise to a person. Maybe he may be a witness, or he may be a police officer, or he may be somebody who has seen something with respect to the crime that was committed at certain point. Next, now if the bail gets rejected, then what? What is the relief that the accused can seek? He can move to the higher court. Now, of course, the starting point is Sessions Court. So if it gets rejected at Honorable Sessions Court, the person can move Honorable High Court, and as a matter of right. But when it comes to rejection at High Court, he can go to Supreme Court. He can move Supreme Court through special leave petition, that is SLP, but not as a matter of right, but as a matter of something that is mentioned under Article 136 of Constitution of India, that the person can approach. And the SLP, that is the leave which is granted by the Supreme Court, also will be based on the arguments and the merits of the case. They will hear your petition, they will see whether there is any substance, and then do the needful. Next. So now, say for example, this person has already been granted anticipatory bail and he's moving around nicely. He's enjoying his life. And again, he commits some crime, or he just doesn't bother about the conditions imposed on him and he does whatever he wants to do. So is there anything that the police can do about it? Yes, the police or the investigating agency. Now, you may be aware that investigation agency is something like ED or CBI or CID. There are specific specialized investigating agencies such as narcotics cell. They are also officers, but they are not the general police that we were. They can move the court for such a bail, and they can, under section 439 of 2, request the court to cancel the anticipatory bail so that the accused could be arrested. Now, this is very important. They have to follow this procedure and get the anticipatory bail cancelled, because as I mentioned earlier, AB is granted and it is valid till the end of trial. So mind you, at any stage or at any point of while the trial is going on, the police cannot go and arrest this person. But if there is certain condition that is violated by the accused, which are put forth in the anticipatory bail, then the police has to get it cancelled and then they can arrest the accused. So I have mentioned 4 reasons, primary reasons, why the investigating agency or police can put forth their say. One is the person has absconded. Secondly, is not cooperating with the investigation, which was our primary condition. Third is evasion. And fourth is where he is trying to manipulate or influence the witness or intimidate. Why am I saying intimidate? He may be harassing or he may be threatening the witness. Now, the life of the witness, eyewitness, or the victim or the complainant is very important. Say if the victim or the complainant dies, then what? So the protection of witnesses and the victim is responsibility of the police. If that is not happening, then they can move the court for cancellation of the said anticipatory bail application that is being granted by the court, and then arrest the accused. Now, what are the implications? So basically, the court has to look at the nature of accusations. As I mentioned earlier, what is the crime? What is the gravity? The severity of punishment has to be looked into, whether the crime committed says that it is punishment is for 3 years, 7 years, 10 years. That has to be looked into and considered. Nature of evidence, what has the police given or submitted on record as an evidence, maybe statement of people, documentary evidence, CDR tracking report, IMEI tracking report, whether they are putting forth their case in a proper manner with evidences has to be seen and evaluated. So what is the nature of evidence that is being given? Also, the character, behavior of the accused, whether the person is from a reputed family, he's an educated person, he won't commit a crime like this. There are certain reasons to believe that such and such person would not do such a thing. So these all has to be considered. And of course, circumstances peculiar to the accused. Now, this is a very important point. Say, for example, there is a murder that is committed at a X place, and there are 4 people involved in it. Not that just one accused is always in a crime, right? People do crimes together. So there could be 2 accused, 3 accused. In our example, say 4 accused are there. But the 4th accused hasn't really done anything. His name just came there because of some whatever reasons. And the case that has been put forth by the police doesn't really justify his presence or his actions. They are that these 4 people have committed such and such crime, have done murder or dacoity. But does the circumstance really point out to the particular accused that he has committed certain thing? Does it justify? Does it show? That has to be evaluated. So circumstances peculiar to the accused is a very important point that the court has to consider while granting bail. Also, there has to be a reasonable possibility, like I said earlier, that the person may abscond. So the accused will never be present for the trial, and then the trial never really goes till its end. We have to secure presence of the accused at the trial. If he is not going to remain present, you may have heard from your seniors, or if you have attended court, you must have seen that a bailable or a non-bailable warrant is issued against the accused. Then the police just knocks at the person's door, arrests him and puts him in jail. Because even after granting bail, if you don't want to attend the court, then that is violating the condition. Primary condition that your presence has to be there in the court while the trial is going on. Now, secondly, there has to be a reasonable apprehension of the witnesses being tampered. The police can't just say that, oh, he will go and influence the witness because he is his neighbor. But maybe the neighbor is not in talking terms with him. Maybe the neighbor is not residing besides him now. So is there some reason, or is there any opportunity for the accused to really influence the witness? Has to be seen. And of course, it has to be considered that no other person is affected by this. Now, say for example, the person is a thief and he is stealing gold chains. So other people in the area are obviously going to be threatened. So in larger interests of public or state, everybody's protection is responsibility not only of the police but also of the court. While granting bail, they should see, check, evaluate that if the person is a habitual offender, maybe after getting bail, he is going to repeat his actions. So that may endanger the existence or livelihood or actions of other people. That has to be carefully evaluated. Next. Now, I have cited certain landmark judgments here. As I mentioned earlier, this is a classic 1980 case, Gurbaksh Singh. Now, Vipin Kumar Dheer versus State of Punjab is a 21 interesting case. You can read that. Dilpreet Singh in 22. Nandini Sujde versus West Bengal in 22. All this will give you a fair picture of what, how, if of anticipatory bail applications, how their applications got rejected, and how they approached Supreme Court, and how they were granted bail or rejected the bail. So your concept of anticipatory bail applications will be very much clear if you go through these certain judgment. Now, 2023, this is one latest judgment, Ashfaq Alam versus state of Jharkhand. You can go through that. Next. Now, you might have heard of this very recent case, Priya Indoria versus state of Karnataka. It's very interesting to see how the Supreme Court has actually went on to talk about interpretation and application of Section 438 CRPC. Now, since we are talking about anticipatory bail applications and granting of bail, it is very important to understand that a section or a provision in law only tells you a certain typeset, something that is very common. But according to situation, according to the facts and circumstances of the case, every evidence, every witness, anything that is placed on record can be interpreted. For example, I remember in one of my cases, the witness in the box told me that he had kept his taxi window half open. That also means that the window was half closed, and that worked in my favor. And I said, okay, so that means that the the glass of your window was half shut. Am I right if I say this? And he said, yes, that worked in my favor. So there is interpretation to each and everything, interpretation to provision, interpretation to witnesses, interpretation to evidences, and evaluating and understanding the premise of any provision is the most important thing that you can do. In this judgment, they have actually done a very good interpretation of Section 438. For that, you will have to read what is 438 first and then read this judgment. Also, it examines the situation where anticipatory bail is sought in a jurisdiction other than the place where the FIR was put forth. So, for example, the person has committed crime in Maharashtra and the FIR is lodged in Maharashtra. But the person is from, say, Gujarat, and he goes in Gujarat. He is anticipating arrest because he has done something in Maharashtra and he is very scared to come back here because the police will arrest him. So what he does is he approaches the High Court of Gujarat and says, please grant me anticipatory bail, give me protection against this case that crime has been committed in Maharashtra. So whether this can be considered or no is one point that you will understand and come across in this judgment. Also, it sheds light on interpretation and application of all legal provisions that are relevant to anticipatory bail. Also, that influence future legal proceedings concerning constitutional importance. Of course, because this is a Supreme Court case, you should always understand that Supreme Court is so much in line with consideration of constitution. You can approach Supreme Court according to the provisions that are mentioned in the constitution as a matter of right to freedom, right to life, right to air, all such kind of cases. So it basically protects individual rights. What is constitution? Constitution protects every citizen and every individual within the country with respect to its rights. Now, we have been talking about anticipatory bail. You might be anxious to know how do we draft this. Say, for example, I get a client who says, ma'am, I want protection against arrest and please put forth an anticipatory bail application in Bombay High Court. So the first thing I need to do is draft the application, right? So I need to know certain things. First and foremost, understanding the case is very important. The best way to know and understand the case is to talk to the accused himself. He has to be very frank and tell you the truth, what has happened, what has not happened. It also applies for regular bail or even during the trial is going. But here, since we are talking about anticipatory bail applications, understanding of what has actually happened and how he is not connected, because you need to put forth that in the court. So understanding that is important. What are the grounds that you can set in your applications is again important. Saying that the person was not in India, they're saying that the person was maybe traveling to some other state. Maybe the person was, say for example, a student is being accused of a crime at a place, maybe near as at from his home, but at the same time, the person, the student, was giving his examination, maybe university examinations at a certain other place, the center of exam. So is it possible that the person is going to leave the exam, go commit the crime, again go back to the examination center and give exam? No. So these are certain grounds that you can put forth. So you have to understand that. Putting it forth in a proper manner, carefully, and in a precise manner. See, understand, court doesn't have all the time in the world. They give you 2 minutes, 5 seconds and say, okay, shoot, tell me, what is it about? You should have a very clear picture. You should have written it very neatly, very precisely. You can't write novels and run around into words and stories in your application. So your application has to be crisp, clear, precise, and you should be very clear as to what are the grounds, how are you going to present that before the court, and try to convince the court that the accused has not committed or he has no connection with the crime that was committed, and please grant us anticipatory bail so that we have protection against the arrest that could take place. So people generally cite certain standard grounds, such as he is very sick person, he is having diabetes, he's having the blood pressure problem, he's an old person of 75 years, he's a senior citizen, and his whole family is dependent on him. He's the sole breadwinner of his family. He has old parents, one wife who doesn't do anything, and he's the only person who is earning for his family. All these grounds are not going to work. And how do you set your grounds? You have to understand what the case has been put forth by the police. So whatever is available in the form of FIR, maybe remand report, maybe a charge sheet, maybe anything that you have first of all, you're apprehending arrest. That means there is some document on record which points out that you are going to be framed in this crime. So you have to read that, understand that as an advocate, I'm saying, and then put forth your points. So understanding those grounds that they have mentioned for arrest is very important so that you can counter it in your own anticipatory bail application. Now, first is that accused is not prima facie connected. As have been mentioned, he was not present at the spot. He has no connection. Maybe it's a family feud between two people, and I am not connected at all with the family. Neither I know them, nor they are not my family, nor my friends, and I have no idea who these people are. So I have absolute no connection with the said offense. One is that. Second is there is no sufficient evidence. Now, what happens is during investigation and interrogation, police sometimes fail to file certain evidences, or rather they file certain evidences which are maybe pointing out that accused number 1 and 2 are involved, and there is nothing on record to show that accused number 3 was even present at that place or even he has committed the crime. So there has to be some element of doubt. When you're talking about arrest of a person, it's a big thing. You can't just go and arrest somebody, right? So criminal cases, this is the base of criminal law, that any person who's once arrested, people will say, oh, he's been to jail, he was arrested by police. You don't say this in civil matters. People rather take pride, oh, I'm fighting for my property, this is my ancestral property. That doesn't happen in criminal law. So there has to be some evidence, and that some evidence should be sufficient to show that the said accused was involved in the crime. They cannot just loosely say that this person was also, then tag him along with some other accused. So this is two things. And third most important, there are two important conditions and 4 provisos under section 437(1) of CRPC. I would urge all the listeners to go and read this, because these conditions and provisos have to be intelligently interpreted while you are drafting your bail application and putting forth your say as grounds why the person should be granted bail. Next, so what are the most common grounds that generally advocates put forth, or it is said that you some things work in your favor? For example, the first thing that comes to my mind, if you ask me, that the person is a clean person. He has, what do I mean by clean person? He has no criminal antecedents. That means that there is not a single case against him till date. So this person is maybe of 50 years old, working in, say, X bank. He's a manager over there. He hails from a reputed family. He belongs to an educated family, a respected family. Why? Because they have a status in the society. You can't just go and arrest the person. His reputation of God knows how many generations they've been staying there. Now, this is little not connected with people who stay in Bombay. But if you say your native place, people know your grandfather. They know your grandfather's grandfather. I've heard about this guy. He was such a nice person. You might have heard all that. So it's a reputation that just family, and in one go, at one moment, the person will come, arrest you, and all your reputation has gone to drains. So that can't happen, right? So saying that you belong to a respected family, to a well-educated family, shows that possibly you might have not committed the crime. So this is one common ground that advocates put forth. He's a law-abiding citizen of the country. Till 50 years, nothing has happened in his life. Suddenly, what happened? That is very important and has to be evaluated. Thirdly, he will not abscond. He will cooperate with the police. He will be present during investigation, interrogation. He may help in finding certain clues or certain evidences. Maybe they go for spot investigation, and maybe the police is not able to see something that he sees because he's a common man. See, the eye of a police personnel is different. A common man is totally different. So he may help them. So basically, he will not abscond. If he's going to flee, then the court will say, you better stay in jail. You stay in our custody so that you are available for us whenever we need during our investigation, our interrogation, and during the trial is going on. Of course, the promise that you will not tamper with the evidence is very important, because if the evidence is getting tampered, then the case is anyway not going to be of that nature that would be if evidence is placed on record. So tampering of evidence, by the way, it is an offense as per law. And if some person, even an advocate, is found that the person is tampering with evidence. Now, what do you mean by tampering? Destroying. So say, for example, there is some case where there is documentary evidence. So documentary evidence is something that ensures that the thing is right. For example, your birth certificate. That is your documentary evidence for your birth date. Okay. So now, how does it work in certain case or crimes? For example, there is a person who committed crime when he was 16 years old. Now he is 18. The case has come before the honorable court, and the court says he cannot be tried as an adult. Why? Because when he committed the crime, or rather when the crime was committed, whether by him or someone else, this person was 16 years of age. Now, how do you ascertain whether he was 16? His birth certificate, his school leaving certificate is documentary evidence to ascertain that he is of certain age. Now, even if that person has committed the crime, you know for sure that he was 16 years when the crime was committed. He will not be tried as an adult in the normal courts of law, but he will be sent to correction home. And it's a total different setup where you might have heard about Juvenile Justice Act. Under that act, he will be tried, and he will be tried to be reformed, because we believe even in law that kids can reform. They can become better citizens of the country. Instead of putting them in jail with all other criminals and making them a bigger criminal, it's better to try to reform them. And that is the reason why under 18 or underage criminals or accused are being treated differently. So documentary evidence is his birth certificate. So tampering with evidence, and lastly threatening. For example, there is an eyewitness and the accused is granted bail. He comes out and he threatens him saying, I'll kill you at gunpoint. You write on the statement, you sign on the statement saying that I have not done anything. My role is undefined. So if the person is going to threaten the witness, then that's not going to work. Then in that case, the bail will be rejected. So the most common ground that advocate will put forth while placing his application for anticipatory bail in the court is that he will not manipulate, he will not induce, or not make false promise, or will not influence or threaten the witness. So that, why are we doing all this? Because the court has to ensure, we all as advocates also have to ensure that there is fair trial and justice is served in by all means. So that's the reason why these are certain grounds that the advocates follow as well.
So, Sumedha, in our registration form, we got one question that if the accused appears for the hearing of an anticipatory bail, and are there chances that the police might arrest the accused before the hearing? So the accused should not go to the court.
No, the police has to follow procedure. Now, yes, this is a little tricky thing that police may do, but as far as my understanding goes, if the person is approaching the honorable court for anticipatory bail, everything has to get stalled and the person cannot be arrested. Certainly because he is going to tell the court that he is not involved in the crime, and in such cases that will lead to illegal detention, and that may be a bigger offense committed by the police in that case. So no, generally no.
Okay, a participant is asking in a chat box, what are the provisions for jurisdiction? Where does one apply for anticipatory bail?
Generally in the jurisdiction where the person stays, resides, or rather where the crime was committed. So see, basically, if you say Metropolitan Court's jurisdiction changes, okay, as far as Bombay is concerned, if you are aware, there are 75 Metropolitan Courts in Bombay, but there is one Sessions Court for Bombay jurisdiction and one High Court here in Bombay. The other ones are in Nagpur and that jurisdiction will not apply. So wherever in Bombay will go to one Sessions Court and one High Court. So that's not the problem.
Okay, the
I
next
believe
question
in
is,
other places also it must be the same.
Sumedha, the next question is, what are the provisions pertaining to bail, bond, and surety?
Bail bond, you will have to read chapter 33 of CRPC, bail and bail bond.
Okay. If anticipatory bail is cancelled, can one reapply?
The person can certainly approach. So the person may apply, but see, where we talk about cancellation of anticipatory bail, certainly it means that the application for cancellation has come from the police or the investigating agency. And I'm sure they're ready for arresting you. So even before you move your second application, you don't have time. So arrest may happen in that case. But yes, but there has to be certain reasonable ground to approach the court for second bail application. See, now many bail applications come, and if the bail application gets rejected, then you may also approach the higher court. But do you have that kind of time, and do you have reasonable grounds to put forth that the anticipatory bail should be given to you? That becomes difficult. The first one has cancelled because there was violation of certain conditions. So again, whether the court will believe you, that is another question.
Meanwhile, I'll just take a question from the chat box. Can anticipatory bail taken on a holiday?
I'm not sure of this, but holiday court works for metropolitan level, not for sessions court and high court. So it will go in regular court only. There has to
Okay.
be a holiday court for that, wherein bail applications in normal cases are taken up, but not in where judicial custody is being granted. But in such cases, I'm doubtful.
Can rejection of an anticipatory bail application be a mere ground for arrest?
Yes, of course. The court has evaluated the grounds that you have put forth. They have evaluated the grounds that the police has put forth, and then they have rejected your anticipatory bail, which means that you are not eligible for protection by the court. So, yes, they are apprehending arrest and arrest may happen. Sheer rejection will not lead to arrest. Okay. But if the police wants to arrest for certain conditions, for certain situations, they may arrest. Rejection will. Now, there are so many anticipatory bail applications pending at the Honorable High Court of Bombay. Doesn't mean that the person is arrested. No, that's wrong notion. So it sometimes certain bail application, anticipatory bail applications before the Honorable Bombay High Court, I've seen they're pending for around 2 years, 3 years. During COVID time, everything got stalled. So does that mean that the person is arrested? No.
The next question is, when does the relief granted under anticipatory bail expire?
So I have mentioned that the validity or rather the expiry of the anticipatory bail is till the end of trial. So the trial will commence, all the evidences placed on record will be evaluated, all witnesses will be summoned, their statements will be recorded, all those sorts of things will happen and the trial will end. And then there will be judgment pronounced by the Honorable Court in favor or against the accused till protected. If you are acquitted, well and good, you're out of the case. If they pronounce conviction against you, then there is no protection. Then the person will have to go to jail.
Okay, Sumedha, you may answer this, but a participant wants to know what fees do lawyers generally charge for an anticipatory bail application?
Okay, so fees depends on the lawyer, of course. One, the reputation of the lawyer. Secondly, whether it is sessions court or high court, you might have heard that high court fees are higher. So it depends from the like one advocate to another. You cannot generalize anything as such. And also depends on the case. If the case is of that grave nature, say for example, there is some murder committed by 4 people and you are going to represent accused number 3, saying that he has not committed because of whatever reasons, then I think murder is a grave offense and the person may charge more. New lawyers charge less. All those kind of factors are there. So there's no set fees that I can say right as far
Okay.
as.
Any recent developments in the law relating to anticipatory bail that the participant should be aware of?
I think you should read PLEA Indoria because it talks about jurisdiction, whether the person, see, there is something normal thing that people always used to follow. So applying for anticipatory bail within the jurisdiction of the crime committed is something that is very casual. We have already seen. But in PLEA Indoria, uh, there's change in jurisdiction. So that's very interesting. You read that and I think you will get a fair idea as to what it is. Okay, there's one question in the chat I can see. As far as ground of parity is concerned, if ABA of the main accused is rejected on merits, will the ABA of other accused with no role in said crime be rejected on parity ground? No. Generally, bail is granted on the ground of parity, but also note that if bail is granted to a lady, you cannot ask for parity with a male accused. The judge may say that I have granted bail to the lady. So there's gender difference. So even on such grounds, bail gets rejected. Now, in this case, you are asking me that if there is no role and if you are able to prove it in your application of anticipatory bail that the person is not connected with the crime, certainly his bail application will not get rejected. 1 and 2 are not connected with each other at all because you might have known or heard that the case gets separated. Now, accused number 1 is dead, for example. By the time the trial commences in the court, accused number 1 is no more. So, what are we going to do with accused number 2? The trial is yet to happen, right? So, the trial will take place and we'll evaluate all the evidences on record and witnesses, whatever is placed on record pertaining to accused number 2 and try to see whether he has committed the crime or not. Now, I have one case of cheating under section 420. It's a cyber crime wherein accused number 1 is such a habitual offender that he has 15 cases against him and he is in jail continuously. Now, I am representing accused number 2 who has no role in this and he is being framed because of certain reasons. Now, in this matter, what happened is we have separated the case and I'm taking it ahead only for accused number 2. So we will be evaluating all the evidences only against him. So there are certain statements and based on which is against accused number 2, are they applicable to us? No, they are not. So again, here the person who's asking for parity, the answer is no. The bail will not get rejected. The bail will be considered on the merits of the application pertaining to only accused number 2.
Okay, Sumedha, the next question is, suppose a 15-year-old commits a crime. Now, on attaining 21, he gets arrested. The question is, will the trial be in accordance with the juvenile law or the normal process will be followed?
See, in first place, when he gets arrested, the police has to first of all ensure before arrest that the person is juvenile or not. Okay, now since the crime was committed when he was juvenile, it has to go to Juvenile Justice Board, and there cannot be any arrest. They cannot arrest. Police arrests an adult, not a juvenile, not a kid. So in first place, that arrest is itself is illegal if they are doing it. But say they were unaware, he is 21 and they arrest him. But after that, they have to see to it that he was a juvenile when the crime was committed and send papers to the Juvenile Justice Board, and he will be not tried. There is no trial as such, but in the correction home at the board, there will be certain proceeding that will happen against the juvenile, and that will be as per Juvenile Justice Act.
Sumedha, the next question is, can an application for anticipatory bail be filed after a charge sheet is filed?
See, generally, what happens is, I also mentioned in the points saying that you should see the grounds mentioned in charge sheet. But if you see in practice, a person gets arrested before the charge sheet is filed. So whatever the provision says in practice, what happens is that the police arrests the accused first, produce him for remand, and then take him into judicial custody and take their own sweet time till 90 days and file charge sheet. Now, this all depends on the judge as well. If the judge is very strict, they will file it within 60 days also. I've seen that happening. But I've also seen police filing charge sheet after 90 days where the judge says he is entitled to default bail because you have taken your own time and gone beyond 90 days. So anticipatory bail is something that has been to be done in a very early stage, not after so much of time. Because you will be aware, once the FIR is lodged, the accused will come to know from somewhere. He will not be made aware after the charge sheet is filed and the summons are sent to him. But in certain cases, this may happen also. So then they can approach the court for anticipatory because you can
Okay,
read the grounds in charge sheet.
one last question. In the
Yes.
registration form that we got, that most of the times anticipatory bail applications are prepared in a jiffy. So any tips for fresh advocates, what how they should prepare and what proactive measures can they take with regards to the format and other provisions?
Very, very good question. I wanted to point it out. Where I got this opportunity thanks to whoever has asked the question. See, at a very early stage of our career or practice, when we start off and we are with a senior, many people, even my batchmates and friends, have heard saying, "You have a format for this. You have a form. You have a typeset. Just take it, print, write whatever. Like, just change the name of the parties, put your case number and give it." No, it doesn't work like that. See, you have to understand that drafting, pleading are the two important, very important factors of practice. Okay. So pleading is one that you do after you go to the court, but drafting is the base. So you should know what all grounds may not apply to everybody. All grounds may not apply to every case. Maybe there is nothing in the case that may point out and you're writing something, and then obviously it will get rejected. The judge will not be happy if you do something in like 1 hour and just go and give it to him. No, you have to spend time with the case. You have to understand what grounds are made out for your arrest. You have to understand what are the accusations against you and put forth only that is pertaining to you, which is applicable to you. And for that, understanding drafting is very important. Now, if you say tips, one is I would say spend maximum time, even if it is anticipatory bail or otherwise, even normal bail, say for example, even in High Court or in metropolitan courts, or maybe you are conducting a trial, you are the defense lawyer, you have to spend maximum times, you have to read the charge sheet or whatever placed on record, at least go through it 4 to 5 times till the time it just fits in your mind so well that you don't forget even a word of it. And yes, it is possible. Don't think that it is something that is not possible at all. Good lawyers do this, and it has to be done if you have to be aware what your case says. So that if some witness talks something and you said, oh, this is not applicable to me, you don't have time to sit and read at that point. You just have a fraction of second. So whether it is drafting of bail applications or while you are practicing, it's very important to know your case well, to know what you role of your accused is, and thirdly, to understand the defense that you are going to take. So you might have heard your senior saying this is your defense strategy. So all your story, see, the in very simple language, I'll tell you, there is one story that is put forth by the police against your accused, okay? And you are defending him in the court. All that you have to do in criminal law is raise some doubt. You have to get benefit of doubt from the court and put forth reasonable grounds to believe. So you are going to put forth some other story which should run parallel with all the witness statements, all the evidences that are placed on record, so that the court ultimately believes that what you are saying is right and what the police is saying is wrong. Simple example I can give you, say a person is a habitual offender. Now these habitual offenders are easy targets for the police to get arrested, okay? And some phone got stolen at a certain place. Now they see that, okay, at this place, this offender, it is his area of work. They just arrest him. But do they have any evidence against him? Have they tracked his location? Whether the phone existed, whether there was any theft committed, whether the person whose phone has got lost or stolen, have they tracked that phone? Do they have IMEI number tracking report? Do they have any location report? All these are very important things. So when you will understand this, when you read the case, when you understand what is written in it, and when you connect it with the story that the prosecution, the police is telling you. So the tips, there is no quick tip. One is in CRPC, you will get forms. You have a certain format that has to be followed. See, now the applications are not just made out of the blue, right? There is a certain format because we do everything in the court. If you move an application, any application, say you're giving an adjournment application, you're giving an application for certified copies, you're giving an application for, say, deferring your witness for the next date. Any application you make, of course, there is a format. I'm not denying that. But the content of the application has to be applicable to you. The content of the application should be such that convinces the court why are you putting forth the application. Now, say for example, I'm in the court, the witness has come, and I'm telling the court that I'm unable to conduct cross-examination today. So please give me next date. So that's got adjournment. So I'm putting forth an application for adjournment. I have to write reason. I can't just say, give me next date. Why? The witness is here. Your job is to conduct cross. So do it. So I have to tell them, okay, maybe I don't have the case papers. The person is in custody. I've never met him. I don't have material instructions from the accused. These are certain valid reasons as to why I can ask for adjournment. People ask for adjournment because they are not well. Somebody may say, oh, Your Lordship, I'm under the weather. I'm not able to conduct cross today. But you just have maybe little fever. Why not? Your witness, see, coming to the court, getting the witness to the court is not an easy job. The accused is here, you are here, the lawyer, I mean. The witness is here, why not conduct cross? So say, for example, someone has got throat infection and you're hardly able to speak. It is hurting you, or maybe in between, I remember there was certain flu type thing that was happening to people, where people actually, advocates lost their voice. They were talking, but you couldn't hear it. So in such a case, how are you going to conduct cross? So you can write an application saying, your lordship, I am under treatment and I've lost my voice. I cannot conduct cross examination today. There could be any reason. So these reasons basically are the content of your application. Similarly, it applies to any application, may it be anticipatory bail application. You have to justify your grounds, saying that he will not tamper, he will not run away. These are very common things. But is there anything pertaining to you? You should do it. If you're saying that he was not in India when the crime was committed, say for example, it's a cyber crime, you can sit in US and manipulate things. That's fine. You don't have to be physically present in India to commit a cyber crime. That's what the court is going to say. But say, for example, a murder has happened with a knife and you were not in India. Somehow you, God knows how you got framed in this, and you were in, say, USA. You can produce the, justify your stay, say maybe hotel bills or something like that. Say, for example, 17th to 20th, you were abroad. You are placing on record your tickets, your hotel bills, your presence at some conference, maybe some pics, something to justify that you were not in India and the murder was committed. Now, this is something that is pertaining to your case. So, while drafting an application, one thing, please don't rush. Like you just mentioned that applications are made in a jiffy. I'm sorry, you're doing a bad job. If you want to do it well, you have to spend time with your papers, whatever documents you have, whatever instructions you have from your client, and take out time. Of course, as a good lawyer, if you are a very good practicing lawyer, you are short of time. But if you want to do a good job and do it well, because see, it's your reputation in the court which is at stake. The accused will suffer for your mistakes, no doubt about it. But what the judge will say, oh, these people just keep on filing applications, they are irrelevant. One day you come up with a very good application, he is going to just reject it because even he doesn't have time. You are in a jiffy, he is also in rush. The court doesn't have time. So please spend time with your material with regards to the case. And secondly, I would also say that you have to spend time reading and understanding the laws, the provisions, because there's a lot of interpretations. You should read judgments, do a good job. If you cite a judgment in your application, well and good. The judge will be more than happy to see that he has some ground to grant you bail. Not that the judges don't want to give you, but if he doesn't have material in the application, he doesn't find any merit, he's certainly going to reject. So please spend time with all the material that you have and do a good job. Don't do it in rush.
Okay, Sumedha, thank you so much for giving us a practical understanding of anticipatory bail. We can't thank you enough for always contributing to our platform. Thanks. Hope to see you soon.
Thank you so much.